I'm Matt Pichard with NAREITWise.com here in Washington, D.C. at the Marriott Marquis for NAREIT's 2016 REITWise conference. Joining me today is Adam Emmerich, partner with Wachtell, Lipton, Rosen and Katz. Adam, thanks so much for joining us.
Pleasure to be here, thank you.
Now here at REITWise, you were on a panel that looked at privatizations, particularly lessons learned from the last privatization wave we saw from 2005 to 2007. So what do you see as the biggest lesson that the industry's already forgotten?
And so I think one of the lessons learned, which the world has learned more broadly than simply the REIT sector, the REIT privatization sector, is, leverage can be very, very serious, fatal. And I don't think we're in any danger of falling into that trap right now, although the history of the financial world over many centuries shows us that it happens over and over again. So we will again one day find ourselves with bankrupt private real estate ventures of one kind or another induced by overenthusiastic borrowing. I think on the legal side, and talked about it this morning in the panel, the lessons are pretty clear. They're not really lessons that were not followed, in fact, in the last privatization wave. If you look at the law, both in Delaware, which is more active in developing some of these change and control doctrines and privatization doctrines, or Maryland, which has its own unique and generally more favorable, more user-friendly framework for corporate transactions. The rules of the road are clear and have been through doctrines developed going back to the 80s and before. In a change of control transaction, the duty of the board is to maximize value for the benefit of the shareholders. In a non-arm's length transaction, which can be the case where a CEO, for instance, leads a going private, it's necessary to deal across the table with a related party in an appropriate sort of way, employing generally a special committee, independent legal and financial advisors, so that the company side, for the benefit of shareholders and unit holders, gets the best possible deal.
And what should employees of a listed REIT do to get ready in case their company receives a privatization offer?
Preparation, advanced preparation for unsolicited takeover bids or for activist approaches is something that boards and senior management of every public company should be doing. It's not their primary job, but it's something that should be on the annual calendar to understand the rules of the road for responding to takeover bids, whether they're privatization bids or whether they're third-party bids, and responding to activism.
And lastly, what do you think will be the major corporate governance issue for the REIT industry for the remainder of the year?
There's not all that much unique about the REIT industry. Proxy access is a huge trend across the public company sector, and a number of REITs have also faced proxy access proposals or adopted proxy access on a proactive basis. That will continue. The unique thing about REITs, to some extent, is that many of them are UPREITs, and you have questions of governance as between unit holders and shareholders. There haven't been any great scandals or inappropriate behavior in that area. Once in a while you get a question about how things have been arranged in the context of a transaction or otherwise, but it's not an area that's been abused, and it's perfectly appropriate, obviously, to be an UPREIT and to have unit holders.
Adam, thank you so much for joining us.
Pleasure to be here today. Thank you so much.
For more from REITWise 2016, be sure to visit REIT.com.